From Dr. O'Donnell. We had 3 expert reports submitted into evidence from Dr. O'Donnell, the state's expert. We had the defense expert, which was Dr. Stinson, and we had the prosecutor's expert, which was Dr. Atkins. Those reports were stipulated to. Further, although only Dr. O'Donnell is the only one who testified. Further, there was a stipulation by the state and the defense in regards to the SMI, which was submitted and I think it was made an exhibit, but I think it was filed also with the court. And the court has reviewed that and all the cases in this, all the facts in this case, and I told you I would take it under submission and render a decision, and that's what we're here for today. So I have a decision that I signed. It's dated today. Do you have it? Okay. And I have made, I will give you in a minute, courtesy copies for you. It is several pages long. I'm not going to read the whole thing, but it is 8 pages long, and I'll just jump ahead to the conclusion. The court finds, based upon everything I just told you, the reports, the stipulation, the exhibits, everything in this case, the testimony of the doctor, I find that the defendant, Hinton, has proven beyond a reasonable doubt. I'm sorry, not proven beyond the preponderance of the evidence that he suffers from a qualifying SMI condition at the time of the commission of the capital offense in this case. And therefore, he satisfies that diagnosis requirement contained in Revised Code 29.025A1A. I further find that the defendant, Hinton, has also proven by a preponderance of the evidence that at the time of the commission of the capital offense in this case, on or about May 2nd, 2025, the defendant, Hinton's SMI condition significantly impaired his capacity to exercise rational judgment with respect to conforming his conduct to the requirements of law under Revised Code 29.025A1BI. The defendant, Hinton, has thus met the statutory requirements necessary to establish the impairment prong. The court also concludes that the defendant, Hinton's qualifying serious mental illness is not primarily attributable to the acute efforts of using alcohol or any other drug of abuse under Revised Code 29.025A2. Based on the conclusions in the expert reports, the court finds this element satisfied. The defendant, Hinton, has also sufficiently proven his SMI claim. The facts presented by defendant Hinton and confirmed by the various expert reports are sufficient to establish his claim for relief under the SMI law. The defendant, Hinton, has met his burden under the law. Accordingly, this court must dismiss both the death penalty specifications in Count 1, aggravated murder, and Count 2, the aggravated murder, as charged in this indictment. Having made we have findings of facts and conclusions in law in this report that I have made. I will have this filed today with the clerk's office, and copies will be given to all the attorneys. So with that having been said, Mr. Hinton, the death penalty is now off the table. You and your attorneys have requested that you change your plea in this case, and it's my understanding that you want to make a plea of not guilty by reason of insanity. To do that, you have to substantiate the reason why you want to change your plea. We had a hearing, I think it was just last Monday, about that, and Mr. Bennett, you argued your reasons why you didn't plead not guilty by reason of insanity originally at the first indictment. You filed a motion for me to re-indict and to enter your not guilty by reason of insanity plea. At the hearing last week, I found that you had sufficient cause, sufficient reason to not have filed it earlier, and that I am allowing you to file it now. So I ask, what is the plea of the defendant on the remaining charges in this indictment?
He pleads not guilty by reason of insanity.
Is that correct, Mr. Hinton? Okay. So you've also, and I will accept that, And what I'm going to do is I'm going to request that Dr. Jenny O'Donnell do a not guilty by reason of an insanity report. Okay. A defendant also, in their motion, asked for a rearrangement. I'm denying that motion. Well, I'll deny it in a minute, I think. I don't see any reason to re-indict the defendant. The defendant has not been re-indicted. There's not been a new grand jury indictment. Yes, there's been a modification to the original indictment now, but I don't find any reason for re-indictment. I don't know any case law that would substantiate that, so I would like you to argue why you would like me to arraign him.
So in light of the fact that Your Honor has accepted a plea of not guilty by reason of insanity on behalf of my client, it's not necessary for him to be rearranged. I will withdraw my request for rearrangement.
Okay, I need you to do that by an entry, so please. Yeah. Yes, I would. I'd like you to do that now, so cover ourselves. Okay. Anything from the state on those issues of withdrawing his request for rearrangement and the entering of the not guilty by reason of insanity?
No, Your Honor.
All right, thank you so much. Now, counsel, all counsel, we have a trial date of April 6th. I do not want to change that trial date. I'm going to get a report from Dr. O'Donnell. I'm going to tell her I want that report for our next pretrial, which is February. Can you have that, Ms. Murphy?
Yes.
February 19th. February 19th is our next pretrial. I want her report by then. I advise all counsel, if either the state or the defense wants their own expert, get it and get it now. I'm not continuing this trial date because you don't have your expert. Understood?
Yes, Your Honor. And the state is going to ask that Dr. Atkins do the NGRI assessment of Mr. Hinton. We've already been in contact with her. She should be able to comply by that date. Additionally, I think the statute is very clear that we all only have 30 days to get those reports to the court.
Right. So I'm actually giving you a little bit more time than 30 days, I think. So I also advise the defense, get your own expert and get it done. I'm not delaying. Excellent. Happy to hear that. Okay. If you need entries for your experts to go visit Mr. Hinton, let me know. Happy to sign those. Okay. With that being resolved, okay, I have a couple more things to talk about. I would like to go over my case scheduling order. So I put this order on back on November 25th when I continued the trial date, which we were supposed to have, ironically, this week. And I have put in specific dates. December 10th, which is passed, January 14th, which was yesterday. The next two dates, final pretrial on February 19th, and a pretrial on March 18th, 9 o'clock. Those dates are set in stone, counsel. You adjust your calendars appropriately. I'm not moving those. Adjust your calendars appropriately. Are we clear? I expect all counsel, all of you, to be here on each one of these dates on time. Okay? Are we clear? 9 o'clock, sir. What I'd like to do is do you first. Before I do my docket and before you have to go to any other courtrooms, I will get you here and do you first so you don't have to wait for my docket. I'm going to schedule my docket appropriately, try to accommodate everybody, but I need you all here on those dates. Okay. So I'd like to go further on to the amended scheduling order that I put on November 25th. On April 3rd, I have listed the jurors' report to fill out questionnaires, okay? I have in this report that counsel shall make proposed questionnaires on February 27th. Although the death penalty is off the table, that sometimes will modify questionnaires, and sometimes questionnaires are not even necessary in an aggravated murder case, which is what this is now. However, we all know this has been a very high-profile case. So I'm asking both sets of counsel, do you want to submit proposed questionnaires from the state?
state does.
Okay, from the defense.
Yes, Your Honor.
Okay, then we will keep that date of February 27th. You must present those proposed questionnaires to me on February 27th. On March 6th at 9 o'clock. At 9 o'clock on March 6th, we will all be here and we will discuss those questionnaires. Okay? I have a date of that March 6th is when the jury commissioner will send out their summons. I think I'm going to probably summons about 500 people. We know that not everybody comes. Usually maybe a third of that comes, so I hope that will be sufficient. So that's what I intend to ask the jury commissioner to do, although I may refer to their deference if they think there should be more, we'll do more. Okay? On my amended scheduling order, I indicate that the jurors will report on April 3rd, which is the Friday before the trial date of April 6th. So I'm reconsidering that, and I'm going to change and amend this scheduling order yet once more. What I'd like to do is have that report of the jurors be on April 1st, and here's why I'm doing that. That Friday, the 3rd, is actually Good Friday before Easter weekend. And it's a half day here in the courthouse. So having hundreds of jurors come in that morning and fill out a questionnaire may take them longer than noon. Okay, and the courthouse closes at noon. So I'm gonna move that up to Wednesday, April 1st, I'm sorry. Wednesday, April 1st, to the jurors to come to the jury commissioner's office, get their questionnaires, fill them out. That will give the jury commissioner time to then copy all of those questionnaires and prepare them for you for pickup on Monday morning on April 3rd at 9 o'clock. You can come to the jury commissioner's office or the court and pick up your questionnaire so that you can review those and be ready Monday morning when we start the trial on April 6th with jury selection. Anybody have any problem with that? From the state?
Nothing from the state.
From the defense?
Nothing, Your Honor.
Good, because I'm actually trying to help you all out. All right, the next thing that I want to discuss is that on April 1st, when the jurors come in, I would like to be down in the jury commissioner's office with the jury commissioner and the jurors, although I think we're probably going to have to separate them in several rooms. They don't have the capacity to hold, I think, as many jurors as we anticipate. And I would like your permission to instruct the potential jurors to not discuss the case with anyone, to tell anyone that they're subpoenaed. They won't know what case they're subpoenaed for until they come down and get their questionnaires. They just think they're being subpoenaed for jury duty, but it is for this particular case. And I want your permission to instruct them not to talk about it with anyone, to post anything on social media, not to do anything about this case as I would when we start the trial, when we begin jury selection. Do I have the state's permission to do that without you, without the defendant? I can bring a court reporter if you want me to. I hadn't thought about that, and if you would like that, I will.
No objection from the state. We'll defer to the court as to whether or not you want to bring a court reporter to the field.
Okay, thank you. From the defense.
No objection with respect to the court engaging potential jurors. I'll ask that the court reporter be present.
Okay, I'll do that out of abundance of caution so everyone knows exactly what I said. Are you willing to waive your client's presence for that interaction?
Yes, I am.
Okay, thank you. It may be like 3 different rooms. I'll bring the court reporter to each room that I go to give my instructions. It will be my instructions. However, as you all know, with jurors come in, Mr. Seitz gives a little explanation to the jurors just about jury duty in general, and that's not going to be on the record. That's his little thing that he does. I'm just going to instruct them about this case and not to discuss or disclose it with anyone. Okay? Everyone good with that from the state?
Yes, Your Honor.
From the defense?
Yes, Your Honor.
Okay, great. Thank you so much. All right, moving ahead. So, Ms. Murphy, I'm going to need an amended scheduling order changing this juror's reporting date, okay? All right. Next, on page 2 of the amended scheduling order, dispositive motion deadline is next week, January 23rd. Does anybody anticipate filing any dispositive motions from the state?
Not at this time, no.
From the defense? You have until next week, I'm just asking.
Sorry.
Okay, thank you. Then we have a motion to suppress evidence deadline, also on the same date. Do either side expect to file a motion to suppress next week? Just asking.
No.
At this stage, I don't anticipate that one.
Okay, thank you. I appreciate that. That's fair. Also, on January 23rd, all other pretrial motions will be filed on that date. I'm aware of one motion that's pending, and I believe that's defense motion number 5, if I am correct. That is about photographs that will be admitted. I said that I would hold that in abeyance, and I will still hold that in abeyance, and I'd like to discuss that probably at one of our pretrials, maybe in February. But that's the only other motion that I'm aware of that is pending from either side. Is that the state's position?
That is the state's position. We will convene and we may file additional motions.
Okay. None are filed from the state right now.
Correct.
From the defense. Do you have any other motions than number 5 pending? No. Okay, great. Just so we're all on the same page. Excellent. And then any other motions must be filed by next week on the 23rd. Okay. And then, of course, there are in this order the dates for response and reply and a hearing. The hearing on all of the motions will be on February 19th. February 19th, we're going to hear all motions, all motions that are pending. Okay. A request for a view. Does anybody anticipate? Okay. A view of the scene must be made by March 5th. Okay. Any jury instructions that anybody wants to submit must be submitted by March 5th. Okay? And I'll just say 9 o'clock, because some people say, well, I filed it at 3, or I filed it at 5, or I filed it overnight. No, 9 o'clock for everything. If it's no date, no time, I'm sorry. If there's no time indicated, it's always going to be 9 o'clock. Okay. Now here my little issue is the defendant's expert cutoff was November 12th. The state's expert cutoff December 8th. Those days are past. The only experts I anticipate you could possibly have might be for the SMI, which we have discussed today that the state has indicated they're going to have Dr. Atkins. I don't have any problem with you doing that, even if it's beyond my time in the scheduling order. Any problem from the defense with regards to that?
No, Your Honor, we'll be able to have an expert
Okay, but in my scheduling order, I said all experts should have been disclosed, both the defense and the state. Clearly now, I'm going to allow you to have experts for the for the NGRI, and so it's past that deadline. Any problem, although you disclosed Dr. Atkins for the SMI, not technically for the NGRI, because that was just recently filed by the defense. Any problems with the state giving notice that their expert for the NGRI may or may not be Dr. Atkins out of time?
No problem.
Okay. Further, the defense has not indicated who their NGRI doctor is going to be. Do you know who it is?
So the doctor says,
Okay, thank you so much. That is also being disclosed past the time in my order. Any objection from the state?
No, Your Honor.
Thank you all very much for working together. I appreciate that. Wonderful. Okay, let's see. Is there anything else I wanted to talk about? Further in the order, it talks about, just on page 3, in the last paragraph, about, again, the jury commissioner shall summons jurors from the regular jury pool to appear at the jury commissioner's office. It says April 3rd. I'm going to amend that to April 1st. Other than that, everything else in the order will remain the same, and I'll put on an amended order either today or tomorrow with those dates that we've just modified. Anything else on the scheduling that anybody would like to talk about?
Judge, you were talking about experts, and the experts being SMI and GRI. Just want to note for the record, we did file within the time period an expert on behalf of the state, accident reconstructionist, officer from Museum of
Okay, thank you. Appreciate that. Anything else that you would like to talk about the scheduling order or anything in it? No. Okay. Is discovery complete?
The state has given all discovery it has to date to defense counsel. Of course, pursuant to the rules, if anything new comes to light, we will update. We have not received any discovery from
witness list or anything?
We have received nothing.
Okay. From the defense, I can't remember if I had a discovery cutoff deadline in my order or not. And where are we with discovery on the defense side in regards to the state? Do you have any discovery to give to them?
Well, see, discovery is going to consist of reports from the expert, Dr. Spencer, and then secondly, the list of witnesses that we plan to call later witnesses. Witnesses that you're familiar with because they were at the scene or were at the police station or family members.
When will you be getting your discovery to the state?
I can give you a deadline and I'll certainly have it.
Okay, how long is it going to take for you to get that? Is the trial again is just in a couple months?
I think it'll be next 2 to 3 weeks.
I didn't hear what you said.
2 or 3 weeks.
2 or 3 weeks. So what day would you like? Let's just so we're all clear. It's just good communication.
How about February 19th?
How about February 19th? Is that okay with the state?
That's fine.
Thank you so much, Mr. Bennett. I appreciate that. Thank you from the state. That's good. Okay. Okay, that's everything on my list that I wanted to discuss today. Is there anything further from the state?
So in addition to the entry that we're going to be giving the court to allow Dr. Atkins to have access to evaluate the defendant, we are asking the court to consider the entry taxing costs of the forensic examination incurred by the state of Ohio to the court.
And why would the court pay for that and not the prosecutor's office?
Well, it's been done in other matters. This is part of the case and necessitated by the defendant's motion, so we're asking the court to consider that.
And do you have authority for me that I can approve that?
I mean, if you're asking for like a statutory that the court must approve, then you have the statutory the court shall approve. It has been done. This isn't something that is a new issue. Often experts are taxed to cost the court in cases throughout the courthouse. We're just asking for your consideration here. The total cost is $4,850.
I guess I haven't seen your motion. Is it a motion or just an entry?
It is just an entry.
So I'm going to ask you to file a motion. So here's why. Are you asking that it be taxed as cost in the trial if there's a conviction, or are you asking the court to pay for that right now in preparation of the trial? I'm not sure what you're asking.
Typically, it's cost after the case is completely resolved, and if you will, the settlement of accounts after the fact. And we're asking this to be taxed as cost as part of that. We're not specifically asking you to pay for this now in advance of trial.
Okay. From the, does the defense want to say anything?
No.
Okay. Said Mr. Bennett never. Okay. I don't know. I'm not familiar with this. I don't remember doing this in the past, paying for the state's experts. Honestly, I'm going to have to look into it. I'm not saying no, but I'm not saying yes. I just don't know. So I have to, I really would like you to file a motion. Can you do that for me? That would just help me. File a motion, let me look at it, and do a little research myself, and then I'll give you a decision. And since it's not imminent, maybe on February 19th I'll have a decision for you. Okay? Is that fair? If you wouldn't mind dropping off a copy, I guess file it and drop off a copy for me, I would really appreciate that. Okay, anything, appreciate that. Anything else from the state?
No, not today.
Okay, from the defense?
Nothing, Your Honor.
Okay, all right, thank you all very much. Oh, Mr. Hinton. Hi, Mr. Hinton, I forgot, I didn't mean to ignore you, sir. How you doing? You okay? How are things going as best they can in the jail? How are they going in the jail? Okay, are you eating their food?
Yes.
Is it any good?
Maybe.
Maybe?
So.
So. That's probably fair. That's fair. Are your attorneys coming to see you?
Not this time.
Not this time? I just want to know if your attorneys are coming to see you and you feel that they are adequately representing you, sir.
Yes.
And are they not coming to see you, or have they not seen you since last week? I didn't know what your statement meant. I don't want you to tell me anything that they said.
They
What-
came between,
Please?
they came in between the two courts.
Okay. Do you feel that they're coming to see you sufficiently to your liking? Yes. Okay. I'm glad to hear that. All right. All right. Then I think that's it for today. Thank you all very much. I will look for any motions to be filed by January 23rd. And then I think our next court date will not be until February 19th, if I'm correct, right? I would like an entry, waiving time, signed by the defendant, both entries. Appreciate you all so very much. And Ms. Elaine, if you could give them copies, and here's the original to have filed with the clerk's office. All right, thank you all very much. We're adjourned. Shorter than I thought.